Hello, Colorado. My name is Ryan Malner. I'm a personal injury attorney with Malner Injury Law, and today is Trial Talk Tuesday. So I've got another trial to talk about. This one happened in Fremont County. In this case, the plaintiff was T-boned by the defendant. The defendant was negligent and admitted liability, but the plaintiff also alleged that the defendant had not slept in 24 to 48 hours. And so because of that fact, they actually sought punitive damages, and the plaintiff had pretty serious injuries in this case. Ended up getting a 3-level fusion in his spine, and that's a very serious surgery, obviously, and so you lose a lot of your flexibility, and it means you're going to have a lifetime of impairment. And so I think what happened in this case, and I don't have all the details, but what happened was the defendant was disputing that the 3-level fusion was actually caused just from the injuries in the accident. And that's usually what we see. It's a dispute on causation, not a dispute on liability. And so that's really important when you're making your claim. They're going to dispute, in most cases, they're going to dispute that the injuries were actually caused by the accident. And so that's why documentation, getting the right doctors involved on your case is so important. So anyways, in this case, the demand from the plaintiff was about $2 million, and that would be expected in a case like this where there were significant injuries. And the defendant in the case actually made an offer of $200,000 on the case, hoping to get that settled. It didn't happen. They ended up going to trial. They had multiple experts that testified on the case. And in the end, the jury came back and paid about $289,000 in medical charges and economic loss. And so didn't even quite cover all the medical bills, but came really close to that. And there was nothing on future medicals. I think the future medical allegation was about $700,000. And so you can see that all they got was $289,000, which is not that great. Then on top of that, they only paid about $32,000 for impairment. So that tells me the jury looked at this and said, yeah, we don't think this was entirely related to the accident. And so this was a tough one to swallow, I'm sure, for the plaintiff's attorneys on this one. But we see that happen a lot on cases where the juries actually will mitigate the amount of damages that they give, even if they do give some damages. Now, they did have about $10,000 for non-economic loss or pain and suffering. That is very shocking. Typically, we see a 2 or 3x multiplier on cases as far as results go. So the plaintiff still won the case, but it wasn't a great result. But he'd still be able to seek costs